So welcome. Thanks for coming today. Everybody have a pretty easy drive getting here? No bad conditions? Any unsafe drivers?
Every day.
Every day.
I couldn't see him as I was whizzing.
You couldn't see them as you were flying by. That's good in the safety workshop. Thank you for that. All right, so let's get started. First of all, my name is Gary Glader. I'm responsible for safety and risk management here at CCIG. I know I've seen many of your faces before. I know some of you are clients, some of you may be prospects. Anybody here a prospect to CCIG? Just curious. Everybody's a client. Well, that's good. So welcome. We've got a long presentation today. I will give some breaks and opportunities to get up and stretch. One of the things I like to do in a workshop is to solicit participation. We'll kind of talk about this later, but anyone in the room had an experience with an OSHA inspection before? So yeah, for the benefit of everybody here who has not gone through an OSHA inspection, I may ask you to share some of your experiences, whether they're good or bad, and perhaps what you learned from the experience. So anytime you feel like asking a question, please just throw your hand up, throw something at me, get my attention, because I prefer to answer those questions as they surface rather than wait until we take a break or at the end of the workshop. So got a pretty lengthy agenda. It's a complicated subject, but what I'm going to try to do is to break it down into simple steps so that everyone understands what this is all about, and then more importantly, what you can do in responding to an OSHA inspection to mitigate any potential damages. So I like to talk about some of the things going on in the world of OSHA, and to be perfectly honest, there isn't a lot. There have been years before where there was a lot on their plate in terms of requirements and regulations that they intended to issue. Ergonomics was an issue maybe 20 years ago, and that caught the employer world by surprise. It didn't pan out. It didn't go anywhere. So there's a bunch of things on the legislative agenda. The things that caught my attention, they are intending to revise the PPE standard for construction. But this, I kind of got a kick out of this, but only to the extent that they want to write in the regulation that PPE that's issued to employees actually fits the employees. And I thought, we're going to take months and potentially years to revise a standard to say the PPE needs to fit the employee, but that's kind of how the government works when it comes to this type of stuff. The one that might be more significant, even though in some respects it's already in effect, is a heat illness prevention standard. Anybody here in construction familiar with heat illness prevention and what you need to be doing, giving breaks, making sure that water is available, acclimatizing employees if it's seasonal work and they come back to work in the spring and summer, we want to give them a chance to adapt to the hot environment. So the standard has not been issued yet. When it does, it will be very specific. Now, right now, OSHA can come to your workplace and issue citations for the heat illness prevention standard using what's called the general duty clause. When they have a full comprehensive standard, that gives them the opportunity to issue violations for each specific aspect of the regulation. So instead of one citation for heat illness under the general duty clause now, you could end up with a half a dozen or more. Gives them the opportunity to issue more citations. OSHA is divided into 10 different regions throughout the country. And each region operates its own enforcement program. So within the Region 8, which is where Colorado is located, they pick and choose different things that they're going to focus their attention on. In this particular case, they're focusing on noise exposure, but not in construction. Those of you who've been around for a while know that there's a set of regulations for construction and there's a set of regulations for industry. Even though noise is much more prevalent in construction, they have yet to develop a comprehensive standard for noise in construction, so they just don't emphasize it as much. There's really no method to the madness, and if somebody asks me to explain why, I'm not capable of doing it because it just doesn't make sense. If people are exposed to noise, the standard should be the same across the board, but it isn't. Powered industrial trucks, in other words, forklifts, another area of emphasis. Many employees are injured, some are killed while operating forklifts, primarily because they lack the proper training to do that. Work zone safety, hugely important, especially we talked about driving today. You know what the biggest threat to a road construction worker is today? This. The number of incidents of people who are being killed because of distracted driving is increasing at an exponential rate. People are glued to their screens. So work zone safety, very, very important. It's a very, very dangerous job. Some parts of the country, like Arizona, it's even more dangerous. Do you know when they work in Arizona on roads? At night. So it's a big issue. And for those people who are involved in road construction, it's a good thing that OSHA is emphasizing protections for those people. And something that has always been on the list across the country, not just here in Region 8, are falls in construction. Leading cause of death in construction is from falls. So it's a big issue, and it's what the local OSHA offices are focusing on. So when I explain the next slide, the federal OSHA stats, half of the states in the country are called federal OSHA plans. Colorado is a federal OSHA plan. Where I come from, Illinois, is a federal OSHA plan. But the other half of the states in the country are on federally approved state OSHA plans. Utah is a state plan. Arizona is a state plan. Wyoming is a state plan. They have the same regulations, but it's just a different group of people that enforce those regulations. They are employees of the state, even though they're adopting the federal standards. So the number of inspections that was conducted in the federal fiscal year from October of 22 through September 30th of 23, there were a total of about 35,000 inspections. So those would include inspections that occurred in the state of Colorado. You know, people, one of the things that I've known for some time that a lot of people don't realize is federal OSHA is not a large agency. Federal OSHA employs just over 2,000 people. I believe the EPA is something like 60,000 people nationwide. So if you think about it, the agency that's tasked to protect Americans' workforce is really sparsely populated with employees. And that kind of ties into a point that I'm trying to make here, which is OSHA inspections are really kind of a random thing. If you were in the mining industry, your regulatory agency is MSHA, the Mine Safety and Health Administration. MSHA has quite a few employees, and those companies and employers that are involved in mining have a pretty frequent relationship with their MSHA inspectors. In fact, in many cases, in large operations, the MSHA inspectors are there on site. So this is really kind of a unique concept. When I talk to employers in that particular industry, they've got a great relationship with the regulatory agency. Why? Because they know them. They work with them. They know what their expectations are. When we're talking about OSHA, it's a random thing. Many of you in this room have never experienced an OSHA inspection, which is kind of strange. The problem is when you're not familiar with that process, it can catch you by surprise. And unfortunately, just like any other walk of life, there are good OSHA compliance officers, and there are those that we would prefer that we didn't have to deal with. You don't get to pick who you get that shows up to do your inspection. So the reason for this workshop is to better prepare you to expect the worst and somebody who's looking to. The thing is, the OSHA compliance officers know when somebody is familiar with this inspection process, and the bad ones will prey and take advantage of those who clearly aren't familiar. So I'm going to suggest to many of you that you exercise your rights as an employer, and you have rights. In fact, when you're inspected, the compliance officer will give you a pamphlet that explains what your rights are. Unfortunately, that's kind of a bad time to say, hey, look, could you give me a couple hours to read through the pamphlet? Doesn't work that way. So the point is, the better prepared you are for this random thing, the better chances of a favorable outcome, while protecting yourself potentially from the unscrupulous compliance officer who's looking to potentially make a name for themselves. So there are consequences to an OSHA inspection, and typically what I find most people concerned about is the money. And don't get me wrong, the money is an important element. And when I share with you a little later in the program how much some of these citations can cost, you'll get the idea, yeah, maybe we need to address this a little bit better. But there are financial consequences in terms of the penalty. But for many people in this room, the more important thing is an inspection becomes part of your permanent and public record. Somebody gave me the name of a company. I could plug it into the OSHA database, and it will show me exactly how many inspections they've had since the inception of OSHA. It will tell me exactly what the violations were for and how much money was involved in that inspection. So for some of you, how many in the room are involved in construction? This is hugely important to you. Your potential clients can go to the OSHA database, pull up your name, and see how many inspections and how many violations you've had. Depending on who the general contractor or owner is, that may or may not exclude you from the bidding process. So this is really, really important. Maintaining a clean record, especially for those industries where your record is scrutinized, is very, very important. It's used in these business relationships. The other thing is, we are an insurance broker, and we place the insurance for all of your companies. The underwriters that are insuring your businesses for the various carriers, they know how to go to the website and look this information up as well. So if you're a big contractor and your workers' compensation insurance is generating quite a bit of premium, don't be surprised if the underwriter actually looks up at the OSHA compliance history, because in their mind, a record of many inspections with many violations is an indication that you may not be a safe operation. So the implications of these inspections are many and consequential. So, this is the part where I'll ask you to be honest and share your experiences. Saw quite a few hands go up. My next question would be, for those of you who did raise your hands, do you feel like, if you're willing to admit in front of the group, that you could have been better prepared for the inspection? Anyone willing to admit that? I see some head nodding. I see one person bravely raised their hand. And just curious, in what respect do you feel you could have been better prepared, if you're willing to articulate? Oh, you mean in terms of what they found versus what you thought might have been going on? So obviously, because of the diverse nature of this group, I'm not going to go through a laundry list of things each of your businesses should focus on. To some extent, I may touch on a few key issues. So it's really important to know and understand the regulations that apply to your business. And these books are thick. Part of the skill is skipping through sections that don't apply. If you're in construction and you're working at elevations, I really urge you to become familiar with Subpart M, fall protection, Subpart L, scaffolding, if you work off of scaffolding, which includes aerial lifts. So you need to become familiar with the regulations that have the greatest impact on your business. The other question to ask yourself is, could the problems that the OSHA compliance officer found, could those issues and violations, could they have been prevented? And that's a key question. And I'm going to tease you. What do you think causes more violations with OSHA? A horribly unsafe work environment with unguarded machinery, a job site where people are not issued PPE, or a case where an employee is not following the rules and is engaged in behavior that violates the regulation. Anyone? Yeah. If I didn't skew it by asking the question enough to give you a hint, yeah, it's employee behavior. Well, here's the problem. In the United States, the worker doesn't get the penalty. Now, my understanding is in some of the provinces of Canada, if it's a violation that was created by the employee themselves, the contractor or employer and the employee share in paying part of the penalty. Which country do you think has a little bit better safety program? And why is that? The employee has skin in the game? Interesting. Well, let me ask another question then. Do you as an employer have control over the employee's behavior? If you catch it, if you see it. So here's the point. First of all, if we look at safety from the 50,000-foot view, 90% of all accidents that occur in the workplace are the result of what an employee did or did not do. That's just the fact. Now, in some cases, if we haven't provided the employee with the training, that's on us if they do the wrong thing. Okay? But 90% are the result of what an employee does or doesn't do. If we don't challenge an employee's behavior when they violate a safety rule or do something unsafe, that's on us. And that's how OSHA views it. And I'll talk much more about this towards the end of the presentation because I think this is a key point and a key takeaway for all of you here. And we'll talk about more. And that's how you deal with frustration that your employees are creating these potential violations. Always like to, oh, by the way, you'll receive an email. All of you who came today will receive an email with a copy of the presentation, PDF copy of the presentation, if that would be helpful to you, as well as a link to repeat the same 2.5 to 3 hours of torture that you're receiving right now live. You could repeat that experience, which I'm sure this weekend many of you will be thrilled to watch this presentation again. If you do, please don't let me know. That kind of creeps me out a little bit. So these are the top 10 nations in OSHA. And if you look at them, going to show you a little something here. So if you look at these standards, these are standards, they're numbers. 1926 applies to construction. 1910 pretty much applies to everything except construction. So number one on the list, which makes sense to me, number one cause of fatalities in construction are falls. People are still falling. Too many people are falling to their deaths. That's a big target for OSHA. And if they find a fall protection violation, that's what they're looking for. And then down through the list. So let's dive in. First of all, anybody have any questions?
Go back to isn't this going, or they're trying to get this in effect in the United States of holding the employee somewhat accountable for ocean inspection? Is there a fault? Isn't that trying to take place?
So the question was, is there a movement where OSHA will hold the employee accountable for violations that occur? And to my knowledge, there is not. No.
Whether you have any safeguards against, if you checked every box to prove that you've safeguarded your employees and they still act like dumbass. Sorry.
Perfect. The question was, is there a way for employers to protect themselves in the event that an employee does violate a rule? And that's my silver bullet for the end of the presentation, and I won't reveal it, and you can't leave before then, and if you do, I'm not going to tell you. But yes, and it's very powerful. And it's very simple. And when I explain it, it makes perfect sense. And I would encourage everybody in the room, and I think we've had this discussion before, I encourage everybody in the room to consider implementing the steps that I'll describe to protect yourself in those situations. I'm sorry? Fall protection? It depends on, there's a lot of factors. I actually get into that, how they determine the amount of the penalty. So what we have here, pretty extensive list. These are the reasons that you could be inspected. And we're going to go through them in detail. So OSHA has always had a fatality catastrophe type provision to conduct inspections. And the current fatality catastrophe type criteria for an inspection includes work-related death of one or more employees, or overnight hospitalization of one or more employees, amputation. I actually will do an OSHA record keeping workshop in January where I go into more detail about each of these things, many of these things. I won't do it today, but also a catastrophe and reason for inspection by OSHA is an amputation. And when I say amputation, it doesn't need to involve bone. It could be the pad of a finger that's amputated, and that is required to be reported to OSHA. And many times they will investigate. Or the loss of an eye. Believe it or not, it's not loss of vision. I could literally be on the job and be blinded, but keep my eye organ itself, and that doesn't require a report. I actually have to lose the eye organ and presumably not be able to find it. Lost eye. Can anybody help me with a lost eye? Strange. I mean, I really don't care if I still have the organ or not. If I can't see out of the thing that's in my head, that doesn't do much use. But that's the way the rules are. Again, not a lot of this makes a whole lot of sense. In the case of the fatality, you have 8 hours from your knowledge of when that fatality actually occurred. Understand, there are some accidents where a person may be taken to the hospital, survive for a period of time, and then pass away. It's within 8 hours of your knowledge of that person passing from a work-related injury that you're required to pick up the phone, or use email notification to OSHA. 24 hours following the overnight hospitalization, amputation, or loss of an eye. The one thing that is excluded from inspection, and this should make sense, to qualify this, the next event is to be recorded on your OSHA log, but it would not prompt a phone call to OSHA, and that is the death of an employee that occurs on a public road. OSHA won't come out and investigate that. Who's going to be doing the investigation? Yeah, police, local police. Now, if this happens on a job site where it's not a public road and vehicle deaths occur, then it does need to be reported. So this stuff gets a little bit dicey. All of you in this room are clients. You'll have my contact information. If anyone ever has any questions about how to handle a situation, please give me a call. Be happy to take your call. High-profile accidents, which may or may not include hospitalization or the other things I talked about. Somebody falls on a job site and they break a leg, but it may not require hospitalization. Many EMS departments will pick up the phone and call the local OSHA office and say, we've had a construction accident here. We're dealing with somebody who fell from a scaffold, broke their leg. So even though you were not required to pick up the phone and report that, there is a possibility, a strong possibility, as a matter of fact, that OSHA will show up on the job. So understand, if you've had something happen in your facility, you just need to put that in the back of your mind. I could have an OSHA visit today. And they have the right to show up. So point is, just be prepared. And hopefully this training puts you in a much better position. So maybe spending a few minutes to talk about what you should do following a serious accident would be helpful. Number one, if there's injuries, call 911. I mean, unless it's obviously not a serious injury. But don't delay, call 911, get help out there. Assist EMS in getting to the injured employee depending on the circumstances. You know, some of these job sites are big. It helps to have somebody meet EMS at a large job site to bring them to where they need to go take care of that injured employee. You want to secure the accident scene. You want to protect other people from injury, but you also want to secure evidence. There's a concept in law called spoliation of evidence. Anybody ever heard that term before? So if a machine is involved in injuring an employee, that employee is covered by your work comp, but that employee may also have a legal case against the manufacturer of that equipment. If you do something to that equipment and alter it before that employee's attorney has a chance to pursue the evidence in terms of what might have caused that machine to malfunction, you can be involved in another lawsuit. So I would be very, very careful with equipment and machinery that are involved in an employee accident and injury. So protect that. Contact your management team. Yes, sir.
Not just like heavy equipment, or you need like vans and trucks too.
Equipment and machinery, heavy equipment, maybe a machine in a machine shop. You know, if it's a vehicle, chances are it's going to be taken in for repair. It'll be able to be that's something you want to have a discussion with a claims adjuster that's going to help you. You want to take photographs of the scene. Everybody in this room today is carrying a camera and a video camera. Don't just snap one picture. Take multiple pictures. Close up, wide angle, from multiple different angles. It's digital. Who cares? Take 100 pictures and save it. Those could come in handy. You want to collect as much information as you can from witnesses. Now, bear in mind, if this is a catastrophic event, you've got people that are upset. Anybody ever been present for a fatality? Horrible, horrible thing. Unfortunately, in my career, I've dealt with directly or indirectly, maybe 3 or 4 dozen work-related fatalities. I mean, I'm a safety person. That's what happens. Horrible thing. And I will tell you, in all of those fatalities, I can't think of one that would not have been easily preventable. But we're human beings. Human beings make mistakes, make poor judgment, poor decision making. But I wish I could say that, there was that one where the chunk of blue ice fell out of the Southwest aircraft and crushed somebody's skull. But I can't think of one fatality I was involved with that couldn't have been prevented, which is a shame. So you will, with a tragedy, the ones I described, you do need to call OSHA. But if you're aware of the fatality and it just happened, you really don't want to pick up the phone and call OSHA right away. You want a better understanding of what it was that occurred. You have other duties to make as well, contacting the family. Anybody ever have to make one of those calls? Call a family member, tell them, hey, I've got some bad news. I have. Before I started in insurance, I worked in a chemical plant. We had 2 fatalities. Anyway, best to avoid those situations. So give yourself time. You have 8 hours. Collect information. If you made the call 4 or 5 hours after you've done your preliminary investigation, that's fine. That's legal. You don't have to pick the phone up right away. I would discourage you from doing that. And obviously, prepare for an inspection. All right. We also have, and this is the source of many inspections, which are complaints. So complaints can be filed by an employee, by a union, if you're a union shop, by referral. Now that would be a member of the general public who drives by, sees an unsafe condition at a project, and picks up the phone and calls OSHA. That's called a referral, not a good referral. Most referrals are seen as a positive thing. This is one of those referrals that not so much. An unfriendly competitor, the second lowest bidder. Don't get mad, get even. And that happens too. And a written complaint. So many complaints, and OSHA has 2 different processes for complaints. One process responds to a phoned-in complaint. And this happens by either current employees or in many cases, ex-employee. Why would an ex-employee call OSHA? Yeah, I got an extra grind, right? Although, in one case, this was kind of funny because you will never know who the employee was. OSHA protects the anonymity of the people that phone in a complaint. But most employers, when they get a complaint, are suspicious that it was somebody who had been terminated. I mean, you just have that gut feel, right? We just fired somebody last week. Now I've got OSHA at my door. So in one case, the reason the employee had been terminated was for repeated refusal to follow safety rules and requirements. So as I assisted the employer who called me, I said, make sure you point that out. Not that you know who it was, but it's kind of ironic that just last week you terminated an employee for their failure to follow safety rules. That will resonate with the compliance officer. They want to hear from employers that they're enforcing their rules, which comes back to the question. It'll take me 3 hours to answer your question, but I'm coming back, I promise you.
There are situations where employees have called in, you've dealt with companies where employees have called in false complaints.
Oh, sure. Yeah. Yeah. Or just you read the complaint and it has nothing to do with anything this company even does. It's really sometimes for me at this point in my career, it's humorous to read some of these things. Not so humorous for the employer, but I get a kick out of it. So OSHA understands that people will use this to get even. So they do with the employee before they even contact you. They try to screen out the don't get mad, get even type phone calls. They're being abused. They're literally being abused. I have a situation in which, just to tell you how ridiculous this gets. Well, let me get back to the final point. If an employee or a union or anyone else files a written complaint, that's either an email, a letter. I don't know, anybody write a letter anymore? A written complaint in the OSHA Act, when this was enacted many decades ago, requires the agency to respond in person for a written complaint. No exception to the rule. So I worked with a demolition contractor on a big project in Chicago, and the steward for the ironworkers union for this one contractor, it was a skeleton building that had been demoed, and they were lowering a scissor lift from the top floor of the building to the ground. The steward from the ironworkers union hopped over the guardrail and jumped into the scissor lift to ride it down to the bottom and said, "Ha ha, I took the elevator." So the general contractor and found out about this, went to the steel erection contractor and said, he's prohibited from the job. He's gone. He will never come back. Well, this was the union steward from Local 1 in Chicago. Local 1 ironworkers are legendary in Chicago. You don't mess with Local 1. So what happened was the union called, said, "Will you bring this individual back to the job?" No, this is an idiot. We don't want this type of behavior on our job site. So the union filed a written complaint with OSHA relative to the work my demolition contractor was performing. They were actually abating lead on beams, cutting the beams with a torch. So the iron workers claimed that they were being exposed to unsafe concentrations of lead. So OSHA showed up with an industrial hygienist, spent a day taking samples, only to determine that everything was being done right. There were no exposures to employees. So the union again is pressing the issue. Will you take this guy back? No, we're not going to take him back. Several days later, OSHA compliance officer shows up on a written complaint. The iron workers were complaining about the noise levels they were being exposed to caused by my demolition contractor who was doing work. Everyone was wearing hearing protection, but OSHA had to show up. So they show up, everything's being done right. Union calls again. Will you take our steward back? No, we're not going to take him back. Aren't you understanding this? Several days later, OSHA industrial hygienist shows up on the job site again. Third written complaint. The complaint in this case was, this is a multi-story building, downtown Chicago. There were ready-mix trucks that were stationed pouring concrete, pumping concrete for the floors. The exhaust fumes from the trucks were a potential hazard to the employees working at the job site. This is a big general contractor in Chicago. Union called up. Okay, OSHA showed up. No, there's no problem. Union called and said, will you take our guy back? They were tired of the inspection process because it disrupted the job, and they brought him back to work. He won by using the system. Nice, huh? If OSHA receives a complaint, they may reach out to you to let you know. They may look at it It may not be significant in terms of what risk by the employee was articulated. They may reach out to you by phone, by fax. There will be outreach asking you to respond to the complaint. Now, you don't know who it is, but they will summarize what the nature of the complaint was before they show up and knock on the door. You have a chance to respond to those alleged hazards and violations, particularly if they're totally untrue and you're able to substantiate it. If you respond in prompt manner to that complaint without them showing up, they may not show up at all. Again, if you receive one of these, please, you're a client, feel free to reach out and let me know, and we can walk through that together. There is an opportunity to make it go away without them showing up and conducting an inspection. I do make a note, always be careful with pictures that you send to OSHA. You need to be very critical of what you're taking a picture of and things in the background that you weren't focused on when taking the picture, that when OSHA looks at it, oh, yeah, that looks okay there, but look at that guy working at the edge with no fall protection on. You could send a picture that establishes the basis for a violation with something that was totally unintended to be in the picture. So you need to be careful with that kind of stuff.
Just to stay on that just real quick. If there is a complaint issued and they do come out and inspect, are they only inspecting that issue or they inspect the whole area?
Great question. Now, I could play the game and say I'm going to get to that in about an hour, but would you prefer I answer the question now?
Plan to discuss it in an hour and let me know? That's great.
Well, I'll do one better than that. I'll do both.
Okay.
Answer your question now. So when there is a complaint, generally speaking, OSHA should limit the scope of the inspection to what's on the complaint. However, there's another legal concept called plain view hazards. And what plain view hazards are is that OSHA, while OSHA is at the job site inspecting for no safety data sheet on a tube of that deadly latex caulk, because everybody knows latex caulk is killing tens of millions of people in this country, the ones that eat it. Anyway, I digress. If they spot another hazard like a fall protection violation, they have every right to pursue it. What do a lot of contractors do when they know OSHA's on the job site? Stop work. And I'm going to tell you, that's not a poor strategy. Now, OSHA knows the game that's being played, but they can't cite you for something you're not doing. So plain view hazard. Funny story about that. A client who operated punch presses. Punch presses are amputation hazards. You know, walk into a punch press shop in the old days and wave hi to people, and you'll see a bunch of people raise their hands with no fingers attached. So they got a complaint about a particular machine in this operation that was not guarded. This goes some of the advice I'm going to be discussing in a few minutes. OSHA announced themselves, went to the lobby. Oh, key person in the inspection process? Receptionist. If you have such a facility, whoever's at the front desk needs to be aware of what your protocol is for handling inspections. That's the first person who they're going to greet. Anyway, receptionist said, I've contacted the team. Please make yourself comfortable in the lobby. We'll have somebody come out to help you answer your questions shortly. You have up to, the rule of thumb is about an hour. You have 1 hour to assemble a team to take that inspector on a tour of the facility, in this particular case, a complaint about an unguarded punch press. About an hour later, a couple of people went into the lobby, introduced themselves to the OSHA compliance officer, and proceeded to go back into the shop. When they opened the door to the shop, what had been constructed was a plywood tunnel that directed the OSHA compliance officer specifically to the punch press that was named in the complaint. So what they effectively did was to eliminate the plain view hazard. Now, you're a compliance officer. Wow. But it means the employer knew the process and what their rights were and what the inspector could look at and not look at. Funny stories over the years. Programmed inspections, these are actually more rare, is when OSHA looks at the Dodge reports, they see a big construction project, the construction of a new stadium, there will be inspections of huge projects like that. They're called programmed inspections. Now, you don't get notice of it, but the OSHA office well in advance says we are going to look at these particular projects. There's also special emphasis programs, and good examples of special emphasis programs that OSHA is focused on heavily: fall protections, amputations, and silica in construction. Silica in construction is something that came about, geez, I lose track of time anymore, maybe 5, 6 years ago. It's become a big deal, and they're still conducting inspections. And these special emphasis programs are developed at the national, regional, and even local office level. Something that shouldn't be underestimated are what I refer to as drive-by inspections. In construction, the number one reason for an inspection is drive-by. How many of you are responsible directly or indirectly for safety in construction, and when you drive, you can spot a ladder violation a quarter mile away, right? Extremely visible. Or somebody on a pump jack scaffold with no guardrail, or any scaffold without a guardrail. Easy to see. And if OSHA spots that hazard, they have the documentation for violations before you know they're even there. So if you hear OSHA's there, hey, hurry up, get that guardrail on the scaffold. It ain't going to matter because they got it on film. Now, to collect evidence, and this came up in another case I was involved in, to collect evidence, they must collect pictures on public property. Once they enter private property, they need to announce themselves and obtain permission. If they enter private property and collect evidence, that can be tossed out, even if the hazard existed. But I mean, with cameras and phones these days, you can see it. You can pull off on the shoulder and take a picture. So there's also something called site-specific targeting. I'm not going to get into a lot of detail about this. Many companies are required to take the information from their OSHA log and report that information electronically. Anybody in the audience report that information electronically? Those of you who are doing that, OSHA is collecting the data, the incident rates, based upon what's on your OSHA log. They're calculating your various incident rates, and if you exceed the incident rate for your peer group, you are put on a list to be targeted for inspection. Right now, this does not include construction. Can't explain why. I think contractors have a strong lobby group. If you wanted my honest opinion, why aren't contractors being included in this program? It's Probably a strong lobby. But so what happens and what you record on your OSHA logs is really, really important. When you report that electronically to the government, that data can be used to target you for inspection. I talk about that much more extensively in a record-keeping workshop that we'll do in January. So if you want to come back and be bored for another 2.5 hours, you're more than welcome to come and attend our record-keeping workshop.
We get an email for advertising that by chance?
I hope so. Did you get one?
This one was forwarded to me by our CEO of my company, but I assume he'll get one, but I guess I'm sitting on the list now that I signed up for this. So.
You should be. Did you leave your email?
Yes.
Perfect. So here's how that works. You report your data electronically. They analyze the data. Unfortunately, they used to tell you the different rates that they were looking for, but they won't even tell you that. Used to be that you could find out that your business was actually on a list to be targeted. They're not releasing that information. So this is totally unaware to you. What's the rate they're looking at? Am I being targeted? You can't know that information. So if you're another reason to be inspected, if you're an employer who is supposed to report this, not all employers are required to report this. It gets complicated. I talk about this more in record keeping, but if you are supposed to submit this data and you're not submitting it, you could be subject to inspection. And you'll receive citations and violations for not having filed the data like you're supposed to. What makes me laugh is there are some employers with fine safety programs who report the data. And if your data shows that you're not having any incidents at all, or you're very low compared to your peer group, you might be subject to an inspection because OSHA suspects you're too good to be true. So you can't even be good without risking a potential opportunity for inspection. And so it goes. This is a list you don't want to be on. The Special Violators Enforcement Program, or Severe Violators Enforcement Program. If your business has been inspected by OSHA and receives 2 willful citations, you're put on this list and you will be inspected at a greater frequency. But you'll kind of know it. You won't know when they come, but you'll know that you're on this list for increased inspections. But in my opinion, for you to get a willful violation in the first place, it's pretty significant. And generally speaking, when you see a willful violation being issued, there's probably a good reason why it was issued. OSHA doesn't take that lightly. Willful means you knew that someone was exposed to a hazard and did nothing about it. Now, as we discussed, most of the violations that you may be subject to are things you're not aware of. There are employees that just randomly broke a rule that caused a violation. This is a situation where it can be proven that you have workers in a situation where they could fall on a construction site and you've done nothing to provide them with fall protection equipment or training. Or you're working in underground construction and you're laying a pipe 8 feet deep without any shoring, without any trench box. And they were only going to be in there for 5 minutes. If I had $1 for every contractor who said we were only in there for a few minutes, it doesn't matter. Trenching violations, if there isn't any protection, I can almost guarantee will be issued as a willful these days. No reason to do it anymore. So anyway, this goes on for 3 years following your inspection if you become part of this program. Nobody here is going to do that.
Question for you.
Yes.
Is there an alternate to pass inspections twice, let's say? The reason I say that, we've been actually tested for silicon on 2 different occasions and passed OSHA's tests. So are we off their list?
I can't guarantee that. But you know what? If you were a compliance office and somebody came across the name of your firm, you would be able to go back in the history and see that file? I mean, why would you, if I were a compliance officer, why would I bother having seen that I was there twice and everything was copacetic?
Okay.
I mean, but I can't guarantee anything. So I think it's important, especially if you're in construction. And again, construction's a unique beast in terms of visibility and the work being all over the place geographically. Important for you to know where the OSHA offices are located. Most of my experience, I've been in Colorado this January going on 3 years. Prior to that, Houston for 12, Chicago for 30. Most of my experience with OSHA has come from Chicago. There was a contractor who was working near one of the 3 Chicago local offices, area offices, at a construction site. And literally, the work was being done off of the small road that drove to where the OSHA office was. And they had some earthwork being done. There were some laborers on the job. And as an OSHA compliance officer was in his government vehicle going towards the office, there were 2 laborers that were riding in the bucket of the front end loader, like 200 yards from the OSHA office. So note to self, identify where project is and locate area where OSHA office is. So needless to say, in fact, as I recall the story, because I talked to the compliance officer, he, one of the first questions was, do you know where your project is located? And the foreman or whoever responded kind of looked puzzled, and he said, well, I'm with OSHA and our office is right there. So for the record, OSHA's offices are at these locations here. One is the regional office on Spear. All right, why don't we do this? Why don't we take 5 minutes? Refresh your coffee. We have toothpicks in the back. That will help keep your eyes open for the remainder of the presentation. And we'll see you in a few.
Hey, how you doing? I'm good. How are you?
No, you're good.
Oh, she's asking. Yeah, I did. Yeah, the respirator. That's what actually expects. So it's something. So just a quick question. Sure. As I trip and you ruin your whole presentation. Would you mind like repeating some of the questions that the folks asked? The gentleman who's asked a question which I can hear.
Yeah, I'll do that.
And my buddy who can hear far better than I, 35-year-old younger years, says he's asking some really good questions. I'd appreciate that.
Yeah, Gary.
It's good.
Yeah, sometimes I just get absorbed and I answer the question, even though I think I was having a hard time hearing him.
Yeah.
But I have hearing loss myself.
Yeah. I'm sitting here going,
Yeah, thanks. I'll
appreciate it.
remember to repeat the question.
And I love that you're emailing us the presentation. That would be helpful.
Yeah. save paper. I used to print them, but this is 150 slides long, so
No, I think you're doing it the right way. Works for me.
perfect.
I think I'm in
Oh,
your.
you're good. I'm glad. The rest of your money, man. Set that down.
No, give me last night.
Too. You don't want to come my 70 in the morning. Come the day you have to come.
Yeah. Yeah.
They're doing rock scaling there. Just every morning.
Chips a little here, side, but that's your free one. So, man, I don't know. I don't know.
It's never in. Maybe we should
See what? No, she, so, oh, yeah. Oh, yeah, you know, no, they're. I took the on to your question for you. Sure. What's the CCIG gas supply? Oh, you question. Yeah. Oh, it's like password. We get it. Yeah. So, take trips and. Yeah, it's. Yeah. There you go. Yeah. Well, there was some that dash you think it's into the large. Got on staff. So my second. Oh, nice. Oh, yeah, I think actually my niece and my sister are going to. Yeah. Good one to go to, I guess. And right, I heard it's like you may as well, you know, if you didn't want to buy a car, you could just. But I think that's probably because of multiple breaks though, right? That's great drivers. Yeah. Our valleys can be like, I think I really filed that we adjusted it all. I don't think but I'm sure. I like good place to each of them. Yeah, it's been in an OSHA class. Winter was like, oh, not bad. Yeah, you guys have been. It's happening. Probably. I remember being. That's usually the first. What's the basketball? They get crazy. So all yeah. Yeah. We done. I guess.
Yeah, no, it's been.
Their license to speak different. So, targets more started 3 years since. Right, and some country said it makes a certain years. They told, yeah, I got out attached to that, obviously, yes, well, they're like, they're usually gonna get popular on the, I'll walk with you. I think it's a feeling of guilt, but I can relieve at the same time. Yeah, for sure. What else like it's it was so much it's so funny. My dad, I did more every time because he did my life. It's every what's the point to shout
in defense of that. Well, no, it's also about calling it. I guess it's called part of the seniors. And then they figure out this. The one percent here, I read, selling our wife. Explosion.
Oh. Right here, I'm gonna announce it. All right. Let's pick her back up again. For those of you who want to connect to Wi-Fi, for your online betting service and social media accounts, the Wi-Fi password, you'll look for CCIG guest. The Wi-Fi password is 155 think CCIG, all lowercase, 155 think CCIG 155. What, you got that? All right, before we delve into the inspection process, anybody have any questions? All right. Yes, sir.
Everything that's entered electronically, if you do that, unless you're just keeping your internal forms. Does OSHA have access to your EMR or moderate to compare anything to them?
So repeating the question was, in addition to the information from the OSHA log, does OSHA have access to your work comp experience modification rating? The answer is no. But I'm glad you asked that question, because when you have an inspection, one of the things that you want to impress upon the inspector is your commitment to safety. And even though OSHA doesn't have access to your work comp mod, they understand what it is, because it's a metric of measuring yourself to businesses that do what you do. It compares you to how you stack up against the average in your business. If your mod is a low mod, that is something you want to share with the compliance officer, because that is factual in terms of the actual accidents your company is experiencing, expressed as the work comp mod. So if you have a favorable work comp mod, you want to brag about that. Usually I will tell people, don't share any additional information with OSHA, because it could be used against you, but not in that case. Now, if your mod is a 1.5, yeah, don't bring that up. Don't bring that up. Highest mod I ever saw in my life was a 13.0. Not 1.3, 13.0. It's a long, painful for many, painful story about how they got that high. All right, so the inspection process, here we go. They've shown up. As we discussed before, they have the right to collect evidence from public property. And they do so with, like I said, our phones now have cameras and video recorders. Everybody's carrying one. In the old days, they used to have big, bulky video recorders, and they'd actually take video. When they enter onto a job site or a building, private property, they must announce their presence. And they have credentials that they should show, or you should ask. If they don't show them, you should ask for them. Generally, on large construction sites, they will check in with the general contractor. So if you're a subcontractor and one of your employees filed a complaint, OSHA will show up to the job and they will announce themselves to the general contractor. Now, it is quite common for that word to spread rapidly at the job site. Anybody know what I'm talking about? All right, shut her down. Let's take a break. OSHA's on site, which as I said before, I think is wise advice. Number one, for the safety of the employees, why would it be safer for employees who are involved in potentially dangerous work to stop working when OSHA is walking around the job site looking at everybody? Why do you think that might be?
Distraction.
It's a distraction. And if I'm the employee and I know OSHA's, on site, I'm focused more on where that person might be than what I'm doing. It's actually just kind of a clever bullshit kind of excuse I use, but maybe it'll work for you. Probably not a good time to cop an attitude. Kind of like when you get pulled over for a speeding violation. You cop an attitude with the police officer. Do you think that will end well for you? Do you think you've got a better chance getting out of the ticket if you scream and yell and swear? Probably not. This is no different. So be professional, be polite, and treat the inspector with respect. I will tell you that you will probably, just human nature. We've all dealt with people. You can kind of tell pretty quickly if this is going to be a person you can communicate with or somebody who's going to be more difficult. You're probably going to get that sense pretty quickly. It's just human nature. So if they don't present their credentials, and it's not a big old shiny sheriff's badge or anything, it's just a government issued ID. If they don't ask, you should ask for it, because according to the protocol, they are not to inspect unless they have their credentials with them. The other thing, okay, so here's the part where some of you are going, you're going to create an adversarial relationship with the compliance officer. How many think that that's going to be the way it goes down? Or what you could be establishing with the compliance officer, the process. Do you think you're less likely to be taken advantage of when you show knowledge of this process? It puts you, in my opinion, in a position of strength for you to be able to demonstrate that you know how this process is supposed to work. Sometimes the compliance officer will tell you why they are there. If they don't tell you why they are there, you should ask them, what is the reason for you being here today? And they must tell you. If you're unlucky, it's a programmed random inspection. They're required to tell you that. You're going to go, oh God. Because a programmed random inspection is wall to wall. They have the right to look at everything. If it's a complaint, and we will talk about this more specifically as we touched on already, they are to limit the scope of the inspection to the complaint. So you want to see a copy. They should present you with a copy of the complaint. Now, it won't have the name of the person who filed the complaint on it, as we have already discussed. And you should take a few minutes to read through that complaint. And if you see something on there that is, we don't even do this, this is not something we do here, you need to have a conversation with the compliance officer about that. So ask to see a copy of the complaint. They have to give it to you. If they don't, number one, if you're a client and you're going through an inspection, who have I told you to call repeatedly? Except when I'm on vacation. No, you can even call on vacation. Unless I'm on a chairlift. I don't take my phone out. One time I dropped it and that really sucked. But call. I will help you. I will walk you through the process. My promise. There are different parts of an inspection. One part of the inspection is called the opening conference. That is where you sit down with the compliance officer and they should articulate exactly what they are going to do today. During that meeting, they may ask to see certain programs. They may ask to see your OSHA logs. We'll get to some of those information requests in a little bit. but they establish what the purpose for their visit is. And you can have dialogue and discussion with them. Like I said, if there's something that's like, what's in this complaint doesn't really even apply to what we do here, have those conversations. If you're a union shop, the compliance officer may ask to have the union representative join in on the opening conference and actually participate during the inspection. The special arrangement OSHA has with the unions. You should also agree on the scope of the inspection. You know, exactly what do you need to take a look at? Those things are all worked out during this opening conference. I mentioned before, if you're a foreman at a project and you have a safety director who isn't at that project, you can tell the compliance officer to patiently wait in the trailer until the safety director arrives. Generally speaking, we're talking about an hour. Now, if it's going to be 2 days, the inspection is going to proceed. But it's an opportunity for you to prepare yourself for the inspection. Something that all companies should do, a company representative needs to accompany the inspector at all times. I can't tell you how many experiences I've had after the fact, after citations were issued, when I asked, when the compliance officer showed up, the business said, hey, I got nothing to hide. Just go ahead, take a look, walk around, come back and tell me what you find. No, not good advice. You need to be right there. You might be able to answer questions that result in the compliance officer perceiving this hazard differently. You need to be there. I actually suggest 2 people attend the inspection. One person is there to guide and answer questions. The other person, I can't multitask, is there to take notes. One person is there to answer the questions. The second person is taking quick notes of the question that was asked and the answer that was given. It's okay. You know, this is one thing we learn in safety. It's okay to tell somebody, I don't know, but I can get you the answer. It's better to say that than to guess and guess wrong. Yes, sir. I guess you could ask the question was, are you allowed to record the conversation? Generally, if the compliance officer asks to record, I tell the client to politely decline. I've never been asked the question about whether you can record the compliance officer. So as I was about to make my point, I don't know, but I can find out. I have attorneys I work with that specialize in OSHA. But for right now, honestly, I don't know. In some respects, that could be a little bit threatening or off-putting to the compliance officer. So I guess my answer would be, I would be more inclined to ask if we could record if it was more of a confrontational situation with the compliance officer. If they're cooperating and it's going well, maybe there would be less of a need to do that, if that makes sense. During the tour of the job site or the plant, the compliance officer is going to take pictures. They have the right to do that, and video. I urge you to take pictures from exactly the same angles and position as the compliance officer, in addition to other angles and positions that they have not taken pictures from. Pictures are two-dimensional, and angles can be very deceiving. You could set a situation up where the picture you take without measurements gives the appearance of something that it is not. So taking multiple angles is a way of protecting yourself from different views and perspectives. And you want to limit the inspection to the scope that was agreed upon. For example, inspector says they are there to inspect for potential fall protection violations. And during the inspection, there's a gang box. The OSHA compliance officer says, hey, I want you to open the gang box. I want to see what chemicals you have stored in there. You have the right to politely say, well, the complaint was actually focused on fall protection, hazards and potential safety data sheets on what's in the gang box, kind of outside the scope of the inspection. And again, is that potentially confrontational? Yes. But again, you're establishing your knowledge of the process. They are supposed to limit the scope to the complaint. And if the compliance officer pushed back against that during the inspection, when I would join you at the informal conference after the inspection is conducted, I would reveal that to the area director of that office, which would embarrass that individual that their compliance officer didn't follow the agency protocol. So by pushing back and saying that's not within the scope of the inspection, I would encourage you to do. It shows your knowledge of the process. And a reasonable compliance officer, number one, is going to ask. But a less reasonable, but still has some modicum of reasonability to them, when you push back, will comply.
What's gonna be the line between within business site, something that they wanna look at or see, or notice, to maybe actually going beyond that to opening something that they can't see right there?
So the question was, what is plain sight? I guess it depends on how good the vision is of the compliance officer. If it's me, you got a good chance a lot of stuff isn't going to get detected. But typically what happens is you'll find, like on a construction site, portable gas container, even though it's red, even though everybody in the world knows there's gasoline in it, it doesn't have a label. That is a plain view hazard. And that's a citation. Depending on how big you are, it could cost you 16 grand for that missing label. So things like that are easy to spot, bad electric cords, defective tools that you can see, those are all things that if it's in plain view, they can pursue. Something else you need to understand, this gets to be kind of a touchy issue, is the compliance officer can speak privately with employees. If the individual that they want to speak with is a supervisor or a foreman, they are considered to be an extension of management, and the safety director or other manager could be present when those questions are asked, but not a frontline worker. Many times OSHA will take the phone numbers of frontline workers on the job and call them after work. And they have the right to do that. Something you should be aware of, which is really important. Employees in this country, many, think that they have some liability to OSHA if they have done something wrong. They don't know that the law doesn't hold them accountable for the violation. So when OSHA asks an employee a question, well, this tool is defective, this electric cord is damaged. One of the questions OSHA will ask the employee is, has your employer provided you with the training and instruction that this cord is a potential hazard to you? Now, if you're an employee who thinks that you might be culpable under OSHA compliance and OSHA law, how would you answer that question? I didn't know. Because they think that they're going to be implicated with that answer. Now, you can come back later and say, here's the evidence of the training that we provided for our employee. And that is sufficient to take you, but wouldn't it be better? This is a really strange concept. Wouldn't it be better if you told your employees, be honest? Well, wouldn't it be refreshing if the employee said, no, yeah, I knew better. I've received electrical safety training. I know that cord is potentially dangerous. I went ahead and used it anyway. Now, there may be follow-up questions. This is giving you more hints of the answer I'm going to give you. And what did I say? We'd be out of here by 3. I'll get this to you by 2:30. The next question might be, do you ever see your employer walk around and look for potential violations, including unsafe behaviors? And what if the employee said, yeah, that sarcastic safety guy who has no hair and poor eyesight, he comes around once in a while and checks things out for me. And then the next question, which is really interesting, which all goes back to the question you asked and the silver bullet. Well, if your employer has provided you with training and inspects job sites, do you know of employees that have ever been held accountable for using an unsafe piece of equipment or an electric cord like that? And if the answer is yes, that's a really good thing for your company to communicate to OSHA. The point is, you should encourage number one, to some extent, I don't recommend you send all your employees to me for 3 hours. But you need to have a conversation with them about OSHA inspections if that's something that's likely to happen in your business, and say, look, we provide you with the tools, equipment, and training. If we ever have an OSHA inspection, I want you to be honest in answering your questions. You cannot be held responsible financially for a violation. We hold you responsible, but you can answer a question honestly with OSHA, no skin off of your back. Make sense? Now I'm talking about reaching a very high spot in your safety program, but it's something to strive for. Because the thing that always gets people in trouble is the employee who has been trained will say they haven't, and now you don't have a record of the training. Guess what happens? You're guilty unless you can prove yourself innocent, which isn't the way normal courts in the United States work, but relative to compliance, it is. So encourage people to be honest. Sometimes the compliance officer can be disruptive. Haven't had that happen in some time, but it can happen. If that happens, yes, ma'am.
My employees tend to really not like government. Do they have to speak to OSHA?
No. And no, they don't. The problem is that kind of puts you in a hard spot. And I have actually 2 situations in which the employee sticking up for the employer, thinking they were sticking up for the employer, said, you're useless. You do nothing except disrupt our work. We're a safe contractor. I ain't going to talk to you if my life depended on it. Get a subpoena, pal.
I'm sure some of my employees would, but if they walked up to an individual and said, I want to speak to you, and that person says no, will they move on and find somebody else?
Probably.
That would be okay.
Yeah, they're not going to press the issue. I mean, unless it was a fatality where they may be subpoenaed to testify as a witness. Yes, sir.
Can we guide it back to management?
I'm sorry.
Can you guide, have
So
employees just back to say, go talk to the manager?
I would encourage you, if your safety program is covering the basic elements, I would encourage your employees to answer the question. Because it would be really bad if the employee said, my manager told me that I'm not to answer questions and to talk to you about that would be a bad situation. Yeah, so the question was, Should you tell your employees, I'm really not supposed to answer the question, a manager should? Probably best to encourage the employee to answer the question. It gets kind of tricky. Some employees are willing to talk, some aren't. Some employees have an axe to grind and they will not give a truthful answer because maybe they were the one that filed the complaint. Who knows, right? You'll never know. It's also important to understand that once an inspection starts, there may be ongoing aspects of the inspection. They could come back one or more times to ask more questions, to take more pictures, to collect more evidence.
Is the procedure the same each visit on the opening conference, on the scope, going over the scope, or the actual 2 or 3 visits?
I mean, the question was, do they have to go through the same entire process on repeat visits? Informally, like when they come back, okay, I need to talk to so-and-so. They don't have to go through, here's my ID, here's the opening conference, because that's already been taken care of.
Well, if the person that called on a bad OSHA call, just trying to grind the axe, then is that person eventually held liable for saying, why did you lie to us? Why would you send us down a road that's not even there? Would that person who called, can they get in trouble for doing that, for pretty much trying to set you up?
No, not at all. That was all created when the law went into effect.
False accusations about companies, and that person will not be held liable.
So if we look back in history, one of the primary reasons for the formation of trade unions in the United States was safety. And when the OSHA law was written in the Act in the 70s, it was originally discussed that the employees would be just as responsible as the employer for violations they create, but the unions were able to successfully reject that.
Question for you. So, all right, let's say you get an OSHA inspection on Monday. OSHA inspector wants to come back on Wednesday. Are you still open for that visible thing when she comes back to ask questions as well? Or can you pull it like open view? Are you still, if he comes back 2 days later to ask questions of somebody else, does he still have that right for the open?
Yeah, so the question was, on a repeat visit, could you still be held accountable for plain view hazards? Absolutely. I don't recommend the plywood tunnel.
No. Would it be against better judgment to say, all right, who do you want to speak to? Let's bring them in the office.
Absolutely. The question was, if you want to talk to somebody, actually from a functional point of view, depending on the noisy environment, it's going to happen in an office anyway.
So if you have an OSHA inspector show up in a non-official capacity, for example, we run a hospital. If they show up in a non-official capacity, grandma's in the hospital, and they decide, oh, hey, I want to look at your place. Now, are you liable for an in-view item at that point?
So the question was, if the inspector is in a place, public place, where hazards are spotted, what people don't know is when they see a hazard, a drive-by, they phone the area office and obtain permission to proceed with an inspection. So to answer your question, yes, but there's a protocol that they have to follow. So yeah, there will be return visits, potentially. You can, once the inspection is started, no advance notice, they show up, it is what it is. For future visits, you can work things out. For example, maybe some employees aren't scheduled to work that they want to talk to. Those things can happen where you may know when they're going to come back a second time. You will never know the first time. That's called advance notice. The compliance officer or representative OSHA can go to jail for giving you a heads up about an inspection. So there's requirements for them as well.
Are you going to talk about retaliation against a complaint? Because I just wanted to make a comment. You made a comment about who did this and what if they're being untruthful, and we all get upset about that. But we had an experience where you can't even have your employees asking or gossiping or talking about, God, who called? Do you think this person called? And you get into that. Now you've retaliated against that person, and that's a whole nother.
Yeah.
can.
You are,
So you have to be really
you have to be really careful.
to talk about it, not to speculate who did this. Don't let your employees talk about it.
Absolutely, without question. The question was, should you be concerned about retaliation following an inspection? And the answer is absolutely. Now, you can't, and they can't hold you responsible for an individual employee who's gossiping, but if it's somebody who's part of the management team, there is a huge divide between frontline worker and what you're responsible for and member of the management team. And a frontline supervisor is a member of the management team. Now, I'm going to suggest something that you have to be very, very careful with. And thank you for asking the question, Mike, because it caused me to think about this. Some employers, but you have to be very, very careful with this. After OSHA has interviewed them, you may choose to debrief the employee, but you need to be careful with how you approach it. You could say, look, we want to make sure that we've taken care of all the hazards that might be present. Can you share with me what the OSHA compliance officer's concerns were relative to the questions you were asked? And if they reveal something, you can take care of an issue that they were concerned about. But Mike, to your point, you need to be very, very careful. In fact, erring on the safe side by not doing that debrief is probably not bad advice either. I'd give it a toss-up. I've been involved in both.
What happens if the employee were to go back to OSHA, letting them know that we were trying to basically like interrogate them?
That would be a problem.
That'd be a problem.
Yep. The last thing is, and this is the piece of the puzzle that I've found doesn't happen in a lot of cases. And it's something to point out to OSHA because they're not following their protocol. When all the work is done, and when I say all the work, that means on-site inspection work, review of interviews with employees, review of the records that they will ask. We'll show you the laundry list of that. What the OSHA compliance officer should do is complete a closing conference. And at the closing conference, what they do is they reveal the list of potential violations that they have found. This isn't a final list. It isn't what you're going to get in the mail, certified mail return receipt required, but it's a potential list. If you don't get the closing conference, you should ask the compliance officer, look, I'd like you to summarize what you have found that is of concern to you and take copious notes. And if you're concerned, ask them for the standard number that they are citing. Each regulation has a standard number. Ask them to be very specific. When you receive the citations, it will be specific.
They have a lot of procedures and protocols to follow.
Yes, sir.
A lot of things. Now, the first 48 hours of them saying, hey, there's been a complaint, or we noticed this, this is what's going on, and you provide them immediate data, you're just in a black hole forever. Days, weeks, months. Oh, without doing a close up, without knowing if there's gonna be a penalty, without knowing what their conclusion is, how can you get them to be on the same page or respond?
Well, as I suggested, if they haven't summarized this through the closing conference, ask for one. The only other, so the question was, this could go on indefinitely, not indefinitely,
But you don't know.
but 6 months. If you have not, oh, I got a funny story about that. If you have not heard from OSHA within 6 months of the day the inspection started, they are unable to issue citations after that point.
They have to issue just a conclusion of what potentially the things are, or
Well, that's
full citation.
by the closing conference, is potential violation. Usually what happens in practice, they will give you a list of 10 things, you get the citations at 6. Usually in most cases, it's pared down. In one case involving confined space violations, government inefficiency, the compliance officer within a day of the 6-month limit delivered confined space violations for $165,000. And they had to hand deliver it because one day later, procedurally, it would have had to have been thrown out. So there should be a summary. The one part that OSHA typically doesn't do is, not typically, often doesn't do is this closing conference. You should ask for it. Be forthcoming. Again, it shows your knowledge of the process. And showing knowledge of process, I think, is a benefit.
Does it give you fighting power on anything that they don't conduct that, don't do their inspection?
So the question, sure. Yeah, the question was, does it give you firepower if you get a citation for something they didn't even mention? What I would do if I were joining you at what's called the informal conference is to push back in front of this compliance officer's boss, the area director, and say, hey, look, we were very cooperative. We were very clear. We asked for a list of citations and this one came out of the blue. Is it going to eliminate it legally? Maybe not, but it shows you acted in good faith and his compliance officer did not. During the inspection, things that you should share with the compliance officer. Generally speaking, I'm not a lawyer, but good legal advice is if they don't ask for it, don't show it, with the exception of these 3 things. Number 1, we talked about it, favorable work comp mod. Got a client just yesterday, saw their most current work comp experience mod. Electrical contractor, 0.59. 0.59, pretty darn good. Something to brag about. I'd share that with OSHA. How many of you track your OSHA incident rates? If your incident rates are much better than your peer group, share that information with OSHA. They're going to look at your log anyway, and they're going to calculate your incident rate, but brag about it. Your knowledge and showing them that you track this stuff, that's important stuff. And anything you can articulate to OSHA that shows that you actively get your employees involved in the safety program. Hazard reporting, behavior-based safety observations that employees conduct. Whatever you can do that shows that you get your employees involved in the safety program is a big plus. So, little tip here, coming back to a question that was asked: how can you protect yourself from the random act of employees? Particularly important in how this whole thing is evaluated are written policies and procedures. Everyone in here should have some type of written safety program with, even if it's just basic safety rules. And then some programs are required in writing, like a HAZCOM program and other programs. Also important is documented evidence of employee safety training. Documented evidence of observations and audits. How many of you conduct routine safety observations and audits? That's great. And I hope those of you who do document them. Because if you don't have the documentation, it doesn't exist. Another tip. Is it realistic if you do inspections over the course of a year that every single inspection is going to be perfect and not identify any hazards whatsoever? Think that's likely? Oh, but, oh man. Now, what if I have to share that information with OSHA? I'm showing them an inspection where we found something wrong. But wow, amazing. Half a dozen people just blurted out, but you fixed it. Yes. So showing a hazard that wasn't addressed, yeah, that's a big problem. So if you have documentation showing that you identified a hazard, please make sure you keep the documentation showing it was corrected. And ironically, some of that corrective action could be in the form of disciplinary action. Funny how that works. So documentation is key. And that effectively is the silver bullet that I'm going to come full circle with. Those are hugely critical things. OSHA can request additional information. They're going to ask how many employees work for that particular company. Now, if you have multiple locations, you can clarify that question and say, do you want to know how many people work here or within the company? Because there can be a difference. They adjust the penalties. One of the adjustments is on the basis of size. So probably not a good time to say, oh, one time we had 3,000 people and you've got like 400, your penalty will be adjusted less the more employees you have.
Is there a number that they say, okay, you have less than?
In the slides. Question was, is there a number? It's in the slides. It's boring material, but it's in there and we'll cover it briefly. They'll ask for your federal employee identification number, FEIN. Ask for an office address and phone number. They'll ask for 300 and 300A forms. They have the right to request 5 years of completed OSHA logs plus the current year log. It is a violation. We complete our logs on a calendar year basis. It's October. If you've had injuries this year and you produce a blank log, that's a violation. Logs must be kept current within 7 business days of your knowledge of a recordable event. So saying, well, I really complete the OSHA logs at the end of the year for posting will get you into trouble. But potentially it's only 16,000, so it's not too bad. Sorry. Training records, they'll ask for training records. They may ask for safety inspections and audits. If you are maintaining these things, as we discussed, all this documentation, this should be music to your ears. I'm glad, because honestly, if they didn't ask, I would work with you and offer to show that information after reviewing it. But this is a positive thing for you to have these things. In construction, they'll ask for contracts because contracts define who is responsible for what. Fault protection at a large construction site typically falls upon the general contractor who may sub that out to a carpenter contractor. But they want to see the contract to see specifically who's responsible for what. Depending on if you need time to pull this information, generally they give you, 4 or 5 days. If you're having trouble pulling it together, they're usually pretty cooperative to say, hey, give me a couple of more days before I get this information to you. Honestly, though, the more promptly you can respond, the better it's going to go for you.
Real quick, we have our safety now on a computer platform. To show these things, do you suggest we sit down with them in front of the computer or say, I can print these out for you and give them to you later?
The question was, if you maintain all this data electronically, should you sit down with them at the machine and review it or provide paperwork? I ask them. It might be easier instead of having to print everything to say, here's our platform. What do you want to look at? Maybe that'd be easier. And, he's taking notes and it'll go away. I give him the option. Most inspections involve what's called the safety compliance officer. There is another group of employees that work for OSHA that are called industrial hygienists, which you probably encounter with the silica. So sometimes what happens is a safety compliance officer will show up at a place of business, let's say for a comprehensive inspection, not a complaint. So they're going to look at everything and they're going to say, oh, wow, there's some sandblasting going on here. And I'm not qualified to be able to assess the exposures for silica. So what happens is you may get a second inspector showing up to pursue questions about the silica exposure or other health-related exposure. And believe it or not, the way OSHA works is that's actually a second inspection. You have one inspection open on the safety side, second inspection open on the industrial hygiene side. If OSHA says, yes, sir.
In the event that that happens, you do inspection, and that puts you on the ask.
No. Well, if there's willful violations issued, that's only if two willfuls are issued. As an employer, if OSHA says we are going to send somebody to take personal exposure monitoring, somebody's exposed to silica, somebody's exposed to lead, whatever hazard it might be, noise, you as the employer have the right to arrange for duplicative sampling done at the same time. It's your way of making sure that your results match OSHA's results. So literally, I've been involved in inspections where we helped the client and collected samples. So the employee's wearing two cyclones and pumps to collect silica dust. But we've never had a situation where there was much variability, but you have the right to do that instead of trusting only their data.
Granted a time for, because to make a random call to set up a secondary testing agency, is there a time frame that could be granted there?
Typically. So the question was, is there a time frame granted for you to be able to do that? Usually the way this happens is an inspection starts, and then during the inspection, it's determined we need to come back and do this, which is where you say, let me contact our industrial hygienist who will be here alongside your compliance officer. All right. So after the inspection, it doesn't necessarily have to be over. After the inspector is finished with the interviews and taking pictures and everything else, there's still a work in progress. It's not as though, okay, we're done with this part. Let's wait to see what comes in the mail. And honestly, there are many cases where that closing conference was not done, and the employer, OSHA, is under no obligation to send a letter saying you were free and clear. It's a waiting game. You look at the calendar, oh, we'll cross another day off, getting closer to that 6-month limit. There's no obligation to tell them. Now, you can ask, and I certainly encourage you, if you like to sleep at night, to ask the compliance officer, have you found anything wrong? And if they say, maybe you get a good compliance officer. No, based on everything I looked at, I think you're doing a pretty great job. But they're not under obligation to tell you that, unless you ask. So, a couple of things. Even during the inspection, if there is an issue that OSHA finds during the inspection, correct it. Actually correct it if OSHA says, oh, that looks like a bad cord. Take care of it. Pick the cord up, take it out of service, and go get somebody to bring a good, brand new, undamaged cord. In industry, not sure if they've applied this in construction, there's something called a quick fix. And if you quickly fix something during the inspection, one of two things may happen, depending on what else they find. that citation for your quick fix, you may not even see. They may say, you know what, they acted in good faith. I'm not going to issue a violation for that. Or it's heavily discounted and the category may even be changed to other than serious. So fixing things immediately is important. You want to take pictures of anything you've corrected as evidence that the problem has been taken care of. Purchase orders for equipment that was purchased to eliminate a hazard. You want to get that evidence to the compliance officer as soon as possible. One of the things I urge my clients to do is to hand deliver it to their office. Say, hey, look, you know when you're going to be in your office? I'd like to drop by. I'd like to show you what we've done to correct those hazards. What are you doing by doing that?
Right.
You're being proactive. You're showing good faith. And I'm going to tell you that there are bad companies in this world. I've been doing this for 43 years. There are terrible companies out there. And the unfortunate thing is that OSHA isn't bigger to be able to chase all those bad smaller companies. But OSHA knows they're out there. They know what a good contractor or good manufacturer is and what a bad one is, because they've seen them. And anything you can do to show good faith works in your credit. So I guess what I'm saying is try to take this from an adversarial relationship and try to spin it into a positive where you do your best to impress that compliance officer. It's in your best interest. So I would make the effort, hey, if you're around, I'd like to sit down and show you what we've done to correct the hazards you found. Remember, this is before you get them in the mail. Because as that compliance officer is sitting down with his supervisor to go, that's what they do. Here's what I found. Here's what I'm thinking about issuing. Gee, I wonder if it would make a difference that he remembered that you made a point of showing up at the office to show how quickly you took care of these problems. It counts. If you believe something didn't exist or the hazard doesn't exist, this gets kind of complicated. Push back. I disagree. And I disagree for these reasons, whatever it might happen to be. Again, if you give me a call, I'd be happy to work through those issues, whatever it might happen to be. Bottom line, it is always easier to make citations go away before they're issued in writing. Once you get them in the mail, I can help you with that. And there's even a possibility I could make them go away, but it is always far easier to do that before they issue the citation in the first place. And I can't tell you how many times proactively I've worked with clients before they were issued to minimize the damage. So we have two different worlds we're talking about, construction and everything else but construction. So typical situation we'd find in construction. So anybody have a problem with that? Bad court, right? How many citations do you think could arise from that one bad court? This is really interesting. 4. Here they are. Number 1, the bad court. Number 2, what will happen is the inspector will, do you have a safety program? I just fell off the turnip truck. We ain't got nothing. We do our work. Why don't you go do yours? Get the hell out of here. That probably isn't going to end well for you. So not having a safety program, and that usually is in writing, means in writing, for that court, they can issue a second citation, not having a safety program that would have identified the court. How many are familiar with the term competent person in construction? Everybody knows that term. Got to have a competent person. Does your program include frequent and regular inspections by competent persons. So they asked the employee with the bad cord, you ever see anybody inspect the job? Nah, they barely show up with a paycheck. What are you talking about? So that one right there, that's another citation for no inspections. And the last one, they will ask the employee, has your contractor provided you with training and instruction that using that damaged cord is a potential hazard? Well, hell no. Nobody tells us nothing around this place.
That's how we thought.
Sounds good.
Could they also get you into the, like, the general duty clause?
No, that actually there's a whole separate criteria for general duty, particularly because there's already a standard.
I don't know if they would double that up or not. That's,
Maybe if they were real aggressive.
they're really mad.
So here's the bottom line. You know, the bad electric cord, this is what the current penalties are. So one bad cord, depending on how those answers and evidence you have to back it up or not back it up, that could cost you a bunch of money for one bad cord. Now that's unique to construction. Why it would be handled differently elsewhere? I don't know. I don't write the rules. Also, in construction, you have a unique thing called the multi-employer workplace doctrine. What this means is on a large construction site, OSHA can obviously issue a citation to the employer of the individual that was exposed to the hazard. But they can also issue citations to the employer who created the hazard. HVAC contractor has to place equipment in a building. They take a temporary guardrail down and don't put it back up. They created the hazard, they can be cited in addition to the contractor whose employee was exposed. There's also the correcting employer. Carpenter contractor is told you need to inspect the job, you need to replace any missing guardrails. They dropped the ball, they didn't do it, the carpenter gets the citation. And the controlling employer is the general contractor. Now, as you know, are there any general contractors in the room? I will avoid besmirching general contractors then. But general contractors like to push responsibility on the subs, especially when it comes to liability. The one thing they cannot push onto the subs is their responsibility as the controlling employer. So a general contractor who doesn't have an employee performing work actively on the construction site is still potentially liable as the controlling employer because they are responsible for the entire project. Now, I will tell you that in construction, that has been a very effective way of improving safety on construction projects. Everybody's got skin in the game, so everybody's looking out for it.
On that, before you move on, is there anything on, so we're in the sign, but, and we have subs come and do our work out at different areas throughout all over the place that we really cannot audit with them. Now, to protect us from them doing an OSHA violation, if they get cited doing one of our jobs, just for subcontracting with us, but is there a way to make them liable if they do get hit?
Oh, well, actually, I hear two questions in that. Two questions. Number one, the question was, we hire subs and they do other work. It's unlikely that you would be given a citation if you're not on site. In other words, like a home builder. Home builder might subcontract all the work, but they don't have an active presence on site. Not likely OSHA will include them unless they're on site. So you wouldn't get the citation in that case. In another situation, and this might actually probably apply more to a general contractor, is in a contract, we think it's important. You can't transfer your compliance liability to a subcontractor, but in the contract, you can require them to pay the amount of penalty that you incur as a result of the subcontractor creating that problem. Do you ask to be indemnified that way?
Thank you.
Yeah, great question.
That puts you in that position to control and manage the site.
Absolutely. And OSHA reads those contracts. They go through it with a fine tooth comb. All right. In construction, there are 4 things that hurt and kill more people. This has been the same list as long as this program's been in place, probably 20 plus years. 36% of all fatalities in construction are the result of falls. It's the way it is. And fall protection standards range from, when do you have to be tied off in a boom lift? How many feet? Anytime, 0 feet. Anybody ever been on a 60-foot extension ladder? I've climbed a 40. I don't, too much. You've been on a 60? Yeah. How high on a 60-foot ladder are you physically in a harness and tied off? Answer is never. It's not feasible. So depending on what you do for a living, you're allowed to fall 0 feet, 6 feet, 10 feet in a scaffold, 15 feet and 30 feet for steel erection, and unlimited if you're on a ladder. Please don't ask if it makes any sense.
Never fall if you're using a ladder properly.
Well, that's a good point too. Yeah, those long ladders, what's disturbing to me is to see the wall moving in and out as I'm climbing the ladder. There's a, shall we call it a pucker factor involved in those long ladders? White knuckles. All right, so falls top the list. 15% of the fatalities are people that are struck by materials. That's why we wear hard hats. People get struck by falling materials or struck by equipment, things being moved on a job. 7% electric shock. 5% of fatalities are caught between typically cave-ins, trench cave-ins, which happen, unfortunately, still too often. With a focused inspection program, if they show up and you have program elements they may ask for, do you have a written program, do you do training, blah, 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 you may qualify for a focused inspection, which means they're going to focus on those 4 hazards with the exception of plain view, right? Always have to remember plain view. And I mentioned plain sight. Probably the most common one is an unmarked chemical container. Somebody once asked me if it wouldn't be more productive. Anybody know in crime stories what a throwdown is? Anybody ever heard that term? Throwdown gun? Oh, here's the gun the perp used. You ever heard that term before? Anyway, somebody asked me once, wouldn't it just be easier instead of going through this horrible inspection process just to throw the bad cord out there? Oh, geez, it's a bad electric cord. Yeah, I probably don't recommend it. They thought that might be clever. I'll give them one. Well, if you want to pay a bunch of money and have it on your record, but otherwise, no, I don't usually recommend the throwdown. Violations in construction, pretty easy to spot. I just thought that was an odd picture that I'd share with you. I took that early in my career. But honestly, I see that all the time. See that all the time. What would you tell the guy? Well, yeah. Maybe get a bigger ladder?
Yeah.
But what's this interesting? So do you think the employee got on the top step of that ladder because they wanted to create problems for you? What do you really think the motivation of that employee was? Trying to get the job done. They were just trying to get, which actually, if you think about it, is a noble effort. But your job as a manager and somebody responsible for safety is to discourage that. No job is so important that it can't be done safely. That's the message you have to communicate. And that's part of a culture. I can't fix that. I can help you try to address that and prevent people from really trying to do what they thought was in the best interest of the company, which is to get the job done. But you see that all the time. Same thing. Same thing. No equipment, he got it done.
A little bit, that's the way we hold the cord for
Yeah, that's with a knot in it.
it. So ladders, pretty much.
Yeah, it's just everywhere. Trench. I was only in there for 2 minutes. That doesn't make a difference. Worked with a contractor. He had somebody anybody work in with excavations? Contractor's employee, the trench was varying depths, as they often are. At its deepest point, it was 5 feet. It was 5 feet 6 inches. That's 6 inches too much. OSHA inspections in general industry. We got so many different industries. Here's a video of a punch press operation. Fortunately, this is not in the United States. Yeah, not allowed in the United States. Yeah, there's an amputation hazard, shall we say, associated with that. For general industry inspections, OSHA is going to enter where visitors normally enter. So that's the reception. If you organize an OSHA inspection response program, a key person in that process is the receptionist. They should have some information about who they should contact, how they should handle the inspector, and make them part of the team. There are some duties in industry where you may have contractors that are working on site, doing electrical work, plumbing work, whatever it is that you bring outside contractors in to do. There is a responsibility, if you're in manufacturing, to communicate chemical hazards of the materials that are being used in your facility to those outside contractors, coordinating your lockout tagout program with those contractors, and coordinating confined space activities in any confined spaces you have on your property. So that's really important. There was a situation where a host employer had a roofer doing work on their building, and the skylights were not rated for fall protection, and a roofing contractor's employee fell to his death through the skylight because it didn't support their weight. And the facility owner was held responsible for not attempting to communicate the fact that those skylights were not capable of holding a human. So this kind of expands, and honestly, if you think about it, that's probably useful information for that contractor to have known, although arguably they should have known better themselves. This one's really important. Doesn't matter, honestly, doesn't matter if it's construction or manufacturing. If you employ temporary workers, you are not paying typically for the work comp because you're using a temp service who provides you with the labor. If you provide day-to-day direction of a temporary worker, you are the employer. That employee gets hurt, they're going to file it under the temp agency's work comp policy, but if they're hurt badly enough to prompt an inspection, you are the employer, not the temp agency. That means it's your obligation to furnish the PPE. It's your obligation to furnish the training and everything else that's associated with being an employer. Matter of fact, on your OSHA logs, if you employ temporary workers, their injuries and their hours worked must be included on your log, even though the work comp claim is filed somewhere else. So just a note or two about temporary workers. Typical violations in industry. Here's a bunch of engineers working on stuff. I worked in a manufacturing plant down in Texas, and the engineers were dangerous. Yes, sir.
Sorry to back you up just when you mentioned temporary workers. It made me think, we often have scrappers that show up and take garbage, steel and what have you. They're not a paid employee. They're a useful thing on our job site for cleaning up, but outside of that, we have no responsibility for them. Are we able to be tagged if they don't come in with the proper?
Well, I would tell you from an insurance standpoint, you are you're exposed to liability. If they get injured, they could likely file suit under general liability unless you make a concerted effort to keep them off of the job. Unguarded equipment, you know, there's so much involved in manufacturing. Thanks.
Safety glasses.
Anybody need convincing about eye protection? What's that? Yeah. Yeah, they're rated for it. At least it'll deflect, might nick his head. I taught a OSHA 10-hour many years ago to carpenter contractor. And I sarcastically said, when you're pounding nails, you don't have to wear eye protection because the nail goes into the wood, never comes flying back. Well, that's sarcasm because I've had nails fly back. So this foreman with a glass eye, you know, we were in a room 10 hours. That was back in the day when you taught 10 hours in a full day. You know, some of you guys know I got this glass eye. It was a lot of you guys, young guys, you don't know how I got this glass eye. He said, back when I was an apprentice, he said, I hated them safety glasses. They were uncomfortable, you know, the big bulky ones. They'd fog up, they get dusty. So I didn't want to have nothing to do with them. One day I'm framing, I'm pounding a 16-penny nail. Thing comes straight back, went halfway through my eye. He goes, then make matters worse. He goes, my instinct was to pull that nail out of my eye. And I'll be damned if I pulled the nail, my eyeball's on the nail. And I'm looking at it with my last good eye. Look at him. He's got his freaking eye on a nail. But the most impactful thing was what he told the group. And he goes, anybody who's worked with me since has never seen me without a pair of safety glasses on. I'm thinking, no shit, dude, you're down to one eye. It's a hell of a time to get religion. But he got it. Now he actually wears a monocle because the glass eye don't need to protect it. So he wears this little monocle. Makes him look sophisticated. Anywho, ergonomics, that's a general duty hazard potentially. Is if OSHA comes in, they see a bunch of people involved in heavy lifting activity. Here's the catch. They look at the log, back injury, back injury, back injury, shoulder injury. They could open a case to look at things from an ergonomics perspective. Possibility, just suggesting. So why don't we take a 5-minute break? Looks like I may go until about 11:30. Usually this is about 3 hours. What were you under the impression? 11:30? Perfect. Let's take a quick break.
This is good.
Yeah.
Hey, Gary. Just saying for temp employees, all their countries are accounted for.
Yeah, it's same criteria you use.
And that goes our system is
So aerial lift, yeah, I'm trying to say this not.
All right.
He's coming by.
Oh, general contract.
Except no fall protection in the system.
Yeah.
As long as you're long, you know.
You have the guardrails.
Yeah.
Guardrails.
Which
Yeah.
Oh, so I've seen people. Why is that on?
So we have got a presentation when 3 years old.
So on the scissor lifts,
Why not?
look at the middle rail and see. You know what that means?
Contractors. You know,
Different. Depending on them to do what they were, you're,
Yes.
it's not, it's, OSHA doesn't look at you as you as the judge.
Well, yeah, I'd say so, same thing, right? So if they're not going to fall protection, when they get up on the fence, that's not something.
I mean, you might tell the guy.
Okay.
So, do you guys do a class in OSHA paperwork?
Record keeping.
Yeah.
Yeah, January.
Okay, so that's the January class. We'll be in. And then, interesting, thank you very much. Would you be willing to do a tour of my facility? I'd love it.
Yeah, sure.
I'll talk more. With that said, that'd be great. And I'm another one of the one-eyed guys. Glass eye.
Oh,
Laughing about the monocle. Now he's gonna get me in a monocle.
wouldn't that be awesome?
Oh, it would be awesome. So, yeah.
Sorry for any
Oh, no.
remarks that you.
Let me tell you, the more jokes you can come up with, the happier I am.
Okay,
Okay.
okay.
I, trust me.
Well, if you can't detect my Chicago sarcasm, then I.
My boss is from Chicago. He worked in East Oakland and. Oh, incredible. Grab all of those before they're all gone. But then we have to. So I'm saying that it's the same challenge. It's the same. I want to create smaller, bigger, different. And state health travel, all vice versa, sending to be called inspection.
Sorry?
If you ever had on ocean inspection.
Yeah. And the lead on too, and they'll get
That was now.
they both went well. So we're scared. Guess we could. They always come. Yeah. Yeah. Well,
There's some late or centers that's going on. I'll talk about it. Yeah, I remember. Usually, so okay, just it's a hard play here, but it's there's the reason whatever you develop. It still has more. So the same time.
yeah, also it's not we're still good. For the most part, those will
Get that.
absolutely. This is the industry. Yeah. But great. Some of these synthetic.
Thanks.
Really quite a flag. Like that's so we were been targeted twice, pass in the within their allowable. You know, for airport. Yeah, exactly.
Actually, it's all just from
The way we actually had it mostly are just pure. So. No, that's actually, but. I can hear how it's asked, so. So you know, so I think we'll, that's a little poverty, right? But your peers. What's this? Yeah. Perhaps. So. Just to show I raise this, like they got keep back their case payrolls. So they take us, they take this for hiring new persons today. So it's like, so it's great. All deal, we didn't, we still should be now firing for thousands of change. So it's yellow can watch. It's not sure. Yes, it's we're strong. Yes, close to the out of doctors we to be nice service. The reason why I try to search that is here for some that's because you know it's more young it's more everybody actually follow we can't get beats now we can also something like television. There's they send someone up there and place on the watch. They like a 3 degrees and some sort of traders that's 800 over. So kind of something you only just need to start paying that person.
All right.
Makes sense.
Got a new battery. My voice is back. I was wondering if you listen to my voice. So before we pick up where we were before, any questions? So in the world of OSHA, wow, this thing's loud. The other one had a dead battery to begin with. Now my voice is dead. Okay, so in the world of OSHA, we have different types of violations. Starting with, in only language the government can use, we have other than serious. Wouldn't non-serious have been easier? But I like words. So other than serious, serious, repeat, failure to abate, willful, unclassified, egregious, and criminal. A lot of those sound pretty bad. They are. I wouldn't expect anyone in this room to ever receive one of those. It's the people that aren't in the room that are operating unsafe businesses that are more likely to see something like that than you are. So typically, an other than serious violation is issued for paperwork. Failure to have the OSHA poster, failure to maintain an OSHA log are issued as other than serious violations. So they're more paperwork. Sometimes if an employer has demonstrated good faith, I, working with the client, or an attorney working with the client, can negotiate the category of the penalty from serious to other than serious. Now that's earned through good faith, and it's something that you actually have to negotiate for. Honestly, how many of you have been to an informal conference? You have been to just a couple of people. It's kind of like buying a used car, okay? You say, this is what we've done, this is what we'd like to see. And then the area director and the compliance officer will step out of the room to talk to their manager about the waterproofing or the rust proofing they're going to do on the car. It has a real negotiated feel to it. But if you know what you're doing, you can be successful. For a contractor who's concerned about the penalties or the citations that go on their record, having an other than serious is certainly less impactful than having a serious citation. So negotiating the category of the penalty is something you may want to do. And again, if you're inspected, please call me. I can help. Serious violations are the most commonly issued violations. There's criteria. The employee must be exposed to the hazard. So if there's a hazard, let's say a scaffold is being erected And during the erection process of the scaffolding, the employees erecting the scaffold had fall protection equipment on. But a section of guardrail is missing. Well, if an inspector comes and sees a missing guardrail, unless they can establish somebody worked on that scaffold platform, there's no employee exposed. It was being built. Does that make sense? The hazard must be feasibly prevented. In other words, we can't have something that's impossible to protect from. For example, a ladder. Well, there's nowhere, you can't tie off on the ladder. You have to climb the ladder to tie it off at the top. There's a hazard that can't be protected against. And the hazard exposes the employee to the threat of what they refer to as serious physical harm or death. Feasibility, can't tie the ladder off at the top until you climb it, just the way it is. Repeat violations, this is if OSHA comes out and inspects your workplace and finds an identical or similar hazard to what they found within a 3-year period, that could be issued as a repeat. Problem with repeat, looks bad on the record. It multiplies the amount of penalty you will pay for.
One thing to note on the repeat is from one location. If you have multiple locations, that is also included in the repeat.
You could have an operation in California and in New York, same violation occurs, it's a repeat. Great point.
Now, when you mentioned different branches or companies operating different places, how many employees, will that differentiate it or no?
Clarify to the OSHA compliance officer, we have 300 employees working at this building. That's used to adjust how much you pay for the penalty. If they ask how many employees work for the corporation, then you're going to have to answer that question. Failure to abate. This is bad because OSHA came out and said, you have this violation. They actually give you a time frame it must be corrected by. Depends on the nature of the violation. Could be pretty quick. Could be that you have 3 months to take care of the problem. So they determine what date you have to comply by. If you fail to meet that date, then it's a failure to abate. Most of the time, you don't see this. You really don't see it in construction because that project is done. Willful, you don't want one. You knew better, but you exposed the employee to the hazard. That's bad. That says we don't care about our employees' health and safety. And it's a huge red flag. And it's so powerful. If you were an underground contractor and you're installing pipe, and you don't have a trench box, and you don't have shoring equipment, and you haven't sloped the trench, and you have people installing pipe at a depth of 12 feet, vertical walls, even if you say, well, I wasn't aware of the standard, they look at you and say, if you're in this business, you have an obligation to be aware of the hazards, and 9 times out of 10, they will issue that as a willful violation. Big red flag. I mean, is anybody familiar with you don't have to admit to it here, but in construction as a general, do you do screenings for subcontractors?
Right.
Have you ever found a willful? Oh, good. You have a good group of subs. All right. So egregious. You have to earn. If you get an egregious citation, I'm going to say, man, you're good at being bad. You know, I'm a White Sox fan. I'm proud because I am proud. If you're going to be bad, be the best at being bad. And they were. And I'm proud of them.
Yeah.
We got some examples. I'm a Bears fan, so I'm not sure. I'm not ready to say we got a quarterback yet. Packers always get the quarterbacks.
Yeah.
Russell Wilson will be available shortly.
That's okay. I mean, now we waste ours on first round draft picks. So egregious means usually if you have a construction site and nobody's wearing hard hats and there's an overhead hazard, usually they will issue one citation, failure to have proper head protection. If you earn the egregious, they give you a penalty for each individual who is not wearing a hard hat. Somebody had a question? I wouldn't risk it. Well, I'll give you an answer. It would be willful if OSHA was able to prove that the foreman or superintendent was aware of it. If it was an employee, I've got that silver bullet I'm getting to before you leave today. That answer? All right. So egregious, nobody's going to get it. Criminal, you know it when you see it. Famous case, Elk Grove Village, Illinois, suburb of Chicago. This is actually how, everybody familiar with chemical hazard communication? This was an outfit called Film Recovery Systems. They took X-ray negatives and photographic film, which who has photographic film much anymore, and they would dissolve the negatives in a solution of cyanide to recover the silver, because silver is part of the process. They used cyanide to do it, and even though nobody in the plant read, or few people in the plant read or spoke English, the company actually took the warning labels off of the container of cyanide and exposed employees to a deadly chemical. One employee died as a result of it. Horrible situation. This man went into convulsions on the factory floor. They took he was still living, took him, dragged him into the parking lot and called 911. Which is where 911 found him in the parking lot. They went to prison, the owners. And they should have, right? You know it. This, without question, you don't see this very often. So when you do, it was deserved. So the penalties, here we go. Serious violations, up to 16,131. Other, typically, they issue that at $1,000 for the paperwork violations, but if they want to be brutal, they can go up to 16. Willful, up to 161,000, 11,000 at a minimum for a willful. Repeat is up 10 times, up to 161,000 of what the original penalty was. It used to be that OSHA would have to pass a law to increase the penalties, but now it's a COLA adjustment every year. So that's why you have a weird dollar amount. Is next year it will increase another whatever the cost of living adjustment is. That's what the penalties go up to. There's a complicated formula in adjusting how much the penalty is. But it's really comprised of two things. They call this gravity. Gravity is dependent upon the severity of the outcome. So let's say we're working with paper products and we have an exposure where we could suffer a paper cut. And we have PPE that we issue to people, but they're not using it. Well, what's the severity of a paper cut? Is it going to kill somebody? I guess you could argue blood infection, but whatever. That's viewed differently than somebody who's working at the edge of the roof without fall protection. The severity of the outcome of the fall is likely death. So they evaluate what the outcome is going to be. The other thing is the frequency. So if I have to go to the corner of the roof once a year to hit a reset button, I don't know for what, I'm just pulling stuff out of thin air, and I only do that once a year, it's going to be viewed as less gravity because the frequency isn't there. But if you have people that are working without fall protection every day, where the consequences could result in death or serious physical harm, it's going to be a high gravity violation, and the amount of money that you pay will be more. I don't want to go through a complex formula how you get there. So broken fingernail, not severe consequences. If you haven't had an inspection where a citation or penalty was issued within the past 5 years, you get 10% credit. for a limited time only while supplies last. Back to the car buying thing. They make a good faith adjustment. If you have a safety program, it's in writing. If you have more than 25 employees, a lot of this has criteria to it. The area office ultimately will make the decision, but this is information you should be armed with, because if you establish good faith, make sure that they applied the discount up to 15%.
Does that include 10%? I mean, in addition to?
Oh, yeah. Yeah, these are all additive. Penalties might be reduced by another 15% for this quick fix program that I talked about, which is why it's so important to take care of the problem they identified immediately and let them know with evidence. This is a reduction based on the employer size. If you think about it, the way OSHA's rationale is, if you're a small company, you don't have the resources that General Motors has. So if you have less than 25 employees, they will reduce the penalty by 60% to reflect that those lesser resources than a larger employer would have. Over 250, no. There's penalty adjustment for willful. Why I'd bother going through this number, but anyway, you see that they have a reduction. There are some restrictions. So if you have a repeat violation, they will only reduce the penalty for the size of the company. The willful is only reduced for size and history. The rest of these, again, I think this is so obscure, but you have the information. You will get in, I don't know if I mentioned this, you will get an email that has a copy of the presentation along with the 3 hours of torture that I've subjected you to for future viewing. You have anybody that you're enemies with? Share the video link. All right, when you receive the violations, you have options. You can pay the penalty in full by mail. Wrong. Don't advise that. You can request an informal conference. Ding, 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 ding. You can file a formal contest, depending on the circumstances, or just don't do anything. I know people that have just not done anything. And then they get a notice about how their failure to pay the penalty in full. No negotiating once that happens. You have 15 business days to respond from the time you receive the citations. I always recommend you request an informal conference. Some companies choose to pay it in full. I don't. Remember, this is a random process. You rarely have an encounter with OSHA. If you're a good company and you really make a good faith effort to comply, why wouldn't you want to establish a relationship with the people that regulate your business? You have nothing to hide. You want to talk about the things you do for your employees. This is an opportunity for you to develop that relationship. If you just pay it in full, nobody knows who you are, except the inspector who was out there. Informal conference. I have had extremely good success working with my clients through the informal conference process, up to and including a dismissal of all citations. But you gotta have evidence for that. You get these mail certified return receipt. I know of businesses that they didn't know what to do with the certified mail that came in, and it just sort of sat in somebody's box that it wasn't for. OSHA doesn't care. So usually when you have to sign that you've received something, that should get somebody's attention within the organization, I'd like to think. If you go to an informal conference, and I've had this happen before, and we believe strongly in our case, as long as it's within the 15-day business day window, you can tell OSHA, now sometimes this is a bargaining chip. I think we're going to contact an attorney and we're going to file a formal contest. OSHA doesn't like that either, because then their attorneys get involved. It just becomes more complicated. Maybe they're more willing to negotiate with you at the informal before allowing it to go to a formal contest. I would say this is for a larger case where there's a lot of citations, reputation, and potentially money involved. It's a legal process when you file a formal contest. I have worked with attorneys before, but you need an attorney at that point who's going to work with OSHA's attorneys. I can be there as the safety expert who's working with you, but it's really an attorney to attorney situation. Do nothing, well, that's pretty lame. So what we're at now, and we've been touching on, and I suspect most of you by now know exactly what the get out of jail card free is, but we're going to explain it. It's called the employee misconduct defense. Or actually, I believe the formal is unpreventable employee misconduct defense. So they have this legal concept which really makes sense and which really operates in your favor to address these random and unpreventable situations where employees don't follow the rules. As we discussed, that is an exposure. We talked about it. What might that involve? Well, somebody not following the rules. Somebody isn't wearing fall protection. They're in the boom lift and they're not wearing fall protection. Well, that was a choice they made. But if you've done out everything, the things I'm about to describe, why would they hold you accountable? It was a choice that employee made. And they know employees don't make good choices all of the time. Could be somebody not using PPE. It could be somebody who says, no, I never was trained, but they were trained. So OSHA recognizes that you can't have a foreman or a supervisor looking over somebody's shoulder 100% of the time. Many of your businesses involve individual service technicians that go from location to location. It wouldn't be feasible or cost effective or competitive to have a supervisor join that employee to make sure they're following safety rules. So the employee misconduct defense recognizes the limitations you as an employer have over making sure that employees follow the rules 100% of the time. All of the elements that I'm going to cover have to be in place and they have to be documented. And OSHA might even question employees to validate that what you're saying is true, but documentation is key. I've used this. Maybe the most recent one I should use. I worked with an attorney because it was a large case where an employee fell 30 floors to his death. He was not allowed to wear shorts. They tuck pointers. Everybody know what a tuck pointer is? They work on suspended scaffolds on the outside of a building. They grind mortar joints and they point those mortar joints with mortar, new mortar. Beautiful day, Lakeshore Drive. Guys up on the scaffold wearing shorts. Company had a strict rule. Long pants always required. Well, they're working on a side of the building. The foreman was actually doing work with another crew. At the end of the shift, talk about bad timing, he decided that he didn't want to be caught with his shorts on. So before they lowered the stage to the ground to get off, he took his harness off, took his shorts off, and that's when one of the two suspension cables snapped. He fell 30 floors through the protected canopy, double 2x12s, went through them like toothpicks. 30 floors to his death. We were able to demonstrate that we had rules. We had actually developed the written rules. We actually trained everybody, English and Spanish, with OSHA 10-hour, special emphasis in fall protection. We were contracted to go do safety inspections for this contractor. And even though fall protection on a scaffold is required at 10 feet, they had a zero tolerance policy. We found a job site where somebody hadn't connected at like 3 feet off of the ground. Based on our inspection report, the employee was terminated. OSHA shared that. Now, citations had been issued. We attempted to do this in advance, but they're like, This was a 30-story fall, high-profile accident, slow media day in Chicago. All the news crews are there. They were compelled to issue citations. When we finished at the formal contest process, everything was tossed out. Unpreventable employee misconduct. That was another freak thing. Too long of an explanation for the class. Another simple one. We had a contractor who was on a large front end loader, and I don't know if it was the middle or the end of the shift. In any case, the machine was running and placed in neutral, and the operator got off of the machine to use the outhouse. The machine began to roll on the grade and killed him while he was in the outhouse. Now, the only fortunate thing for him is that it didn't kill another coworker. Because as slow as it was moving, nobody would have heard it if they weren't looking at it. So OSHA inspected. We were able to demonstrate to OSHA that we had rules. Actually, they had proof that an employee and operator was terminated for not turning the machine off when they got off of it. All of those elements, which I'm going to come full circle with here, were used to effectively excuse the employer for some bad decision that employee made. And why would you want to hold the employer accountable when they had done everything they could possibly do to make sure that didn't happen? So, the 4 elements of the defense: establish written safety rules and procedures, communicate those rules and procedures to all employees, affected employees, conduct periodic audits to make sure that the rules that you establish are being followed. And whenever you detect non-compliance with your rules, hold that person accountable. I will tell you that in my experience, which probably time for me to stop experience, but in my experience, so many employers I work with have the first 2 nailed down pat. Yes, we have rules and we do training. How many people in here have rules and do training? Yeah, which is great. Those are the first 2 and critical elements of this defense, where many people start to fall down. Can you show us evidence that you routinely inspect your facilities and your job sites? That's where people start to fall down.
Personal question for after.
Oh,
Because I was gonna ask, we make our guys sign a safety sheet every morning, and we have a 15-minute meeting going over safety. Would that like be adequate to show case of a situation?
well, it would be helpful, but for example, fall protection training, that might be more than a daily 15-minute safety briefing. Do you do OSHA 10-hour? Well, you're in manufacturing.
Yes, sir.
Yeah. Been to your location.
Right, yes, sir.
If you have hazards like fall protection or silica, you need special training for each of those particular subject areas. But what you're doing is perfect. Daily safety briefings, documentation of that's going to help your case. The area where, unfortunately, many employers fall down and because they want to be friends with their employees. When I asked, do you have evidence of disciplinary action for safety violations? Well, we wrote a guy up because he was late for work. That doesn't count. You need evidence that you enforce the safety program. If you don't have that one piece, OSHA says the defense doesn't apply to you because clearly you're not being diligent about enforcing your program. In other words, you're telling OSHA, oh, we inspect our facilities and job sites all the time. And in the last 12 years, we've been perfect. Never been a thing. Never been anybody that violated things. Well, how come you have 10 incidents on the log? And how come some of them appear to involve the lack of PPE use? What are you gonna say? So it's really incumbent upon you. This is tough. How many people have a really fun time trying to find qualified employees? Right? So here I am suggesting that you do something that may be perceived, but honestly, you're doing this in that employee's best interest. You're trying to keep them from being hurt. How does that make us the bad guy? And in fact, I would argue that not saying something and allowing them to engage in unsafe behavior undermines the culture of your safety program. And that's where this whole dynamic of supervisors engaging with employees becomes so important. Yes, sir.
So you mentioned a couple examples of somebody just being terminated when they're not following the right protocol for safety. I guess that's a good example of showing repercussions that you provide for not following your program. However, is there an escalation process?
Oh, absolutely. Yeah, absolutely. I mean, usually what we refer to these as are progressive disciplinary action programs. And I mean, I would tell you that you want to reserve the right to terminate somebody depending on the nature of the violation, right? Horseplay, somebody fools around, throws tools or something like that. I mean, I have zero tolerance for that, so that might be immediately gone. Failure to wear eye protection, maybe it's a 1, 2, 3 and you're out. Does that answer the question?
That would basically, though, ideally, you'd want that written into those established safety rules and procedures, so you have that disciplinary tree or disciplinary process written out.
The one thing I would caution you against, I have seen employers with programs that list the violation and then list the specific consequences. You're painting yourself into a hole. And it would be impossible for any one of us in the room to imagine the stupid things that could be written into a rule that somebody would do on the job. And what happens when you define it to that extent is you create a checklist environment where somebody who's monitoring, oh, well, it wasn't one of these, so I'll just let it go, if that makes any sense. So really, a lot of that is on the skill of the person who's conducting the audit. And for the record, how many of you are in here as safety directors? And in your role, this is going to be a hard question, and it's a pointed question for a reason. In your role as safety director, are you the one that will issue disciplinary action to the employee? I am going to suggest that you don't do that. Are you at every job site every single day? So when a superintendent or a foreman discovers an unsafe behavior, wouldn't it just be easier for them to wait for you to come around to issue the discipline? You think a superintendent wants to tell his buddy he screwed up, going to have to get a write-up? There's a strong reluctance. I strongly recommend you can help. If you're a safety director, you can work with your frontline supervision, but that relationship between the violation and correcting the violation needs to occur between a frontline supervisor or manager and that employee. And you won't convince me otherwise. The fact that you're addressing them, I think, is a good thing. I just think that there's a different way to do it, because what happens is confronting someone's behavior is an awkward moment that most people want to avoid. If I'm a foreman and I know I don't have to do it because the safety director is the one who does it, I'm going to tend to ignore other behaviors.
It also speaks to the quality and the safety culture of your organization. If your frontline supervisor or managers are doing the discipline, that they're bought into your safety culture. So I think that's probably going to be a positive viewpoint from OSHA standpoint.
Yeah. Yeah, and OSHA gets this stuff. They understand how it works. Sure.
Say, for instance, if you did have, say, your foreman or whatever on a specific job site, how do you help to convince them that that's But you're not pawning your job off onto them.
Ultimately, if the system is working the right way, part of that foreman and superintendent's responsibility is to be evaluated themselves on how they're managing projects. If I'm a safety director and this job site with this particular foreman or superintendent always has these issues, then that foreman supervisor needs to address those behaviors. It's honestly, it's the only, yeah, all about accountability. None of this is easy. None of it. And a lot of it is stuff a lot of people may not want to hear. So things that won't work, the three biggest lies, we don't need written safety rules. All of our employees know what the rules are. That ain't going to fly with OSHA. Got to be in writing. Same thing I've heard. I inspect my work area every single day and I make sure problems are taken care of. I don't need to write any of this crap down. That won't fly with OSHA. If you're trying to establish this defense, you need to show them. My favorite. We discipline our employees for safety violations, especially after they suffer an accident. So they can do the wrong thing and get away with it. But once they do the wrong thing and get hurt, then all of a sudden we hold them accountable. And I must be fascinated by the pyramid. Maybe there's a power associated with pyramids that's captivated me, some mysterious tractor beam that pulls me to the pyramid. But this has always fascinated me because it's the foundation of human behavior when it comes to safe work methods. Statistically speaking, these numbers, I think about 4,500 people in the United States were killed on the job last year. Those numbers have gone down. We've now been stagnant, which is, if you think about it, our working population as our country grows increases. So the fact we're stagnant is kind of a positive sign. If you're one of the 4,500 people, not a good day. For every one death in the workplace, there's about 30 serious injuries that occur. Statistically, this is how the numbers shake out. For every 30 serious injuries, there's 300 minor injuries. For every 300 minor injuries, we have 1,500 close calls. Some people call them near misses. I call them close calls. Anybody have a near miss reporting program? Gee, I wonder why. So you don't have to go up here if you're addressing the problem down here. And the more remarkable number, for every 1,500 close calls that result in this one death, there are 20,000 unsafe behaviors that are occurring. The problem is the odds are in your favor that you can do the wrong thing statistically and likely get away with it. But what does that do after repetition? It becomes a habit. You begin to believe, oh, I've done it. How many have heard this? But I did it that way for 30 years. Count your blessings. You got lucky. I could play a game of odds that had 50-50 odds and play that game 1,000 times and not win once. So I kind of know I need to look at the pyramid because if it's going to happen, it'll happen to me. But the point is, I taught this concept to a group of people and he said, well, wait a minute, Gary. And maybe my fault for not explaining it. He goes, the way that pyramid works is I can do the wrong thing 20,000 times. And then after the 20,000th time, I will have 1,500 close calls. And I could have those close calls. And after those 1,500 close calls, he thought he actually would work his way up on the pyramid. I didn't have the heart to tell him with that logic, he was probably headed to the top. But the point is, it's a game of odds. It's a roll of the dice. You can control your odds by doing the right thing. But the reason why this is so important in all of your safety programs, the way to prevent injuries isn't to wait to investigate them. It's to identify the things that are occurring on a routine basis, on a daily basis, and correct those things before they become an accident. So, little work before the inspection to get yourself prepared for this, how to handle it, understanding the importance of the employee misconduct defense. It's going to go a long way to protect your companies. It's a random thing. It's pretty painful when it happens. People are worried about it because they're not familiar with it. I've offered my help as a client. Pick up the phone and give me a call. And hopefully you're walking out today with my goal of any training session is for you to walk out with just a little bit more information than when you walked in. If you feel like you got a little bit more than when you walked in, then I think we've accomplished our objective. Be happy to answer any questions you might have if you want to stay behind for a few minutes. But thanks again for coming. Look for an email with the information. We will have a workshop in January on OSHA record keeping. And you can give me a call or email me at any time. I'd be happy to work with any of you and answer your questions. So have a great day.
Thank you.
Here, I got a question. So we have.
See you back at the office.
Big Mac is very hard. Oh, garden. Germany fall.
Mara?
Yeah. Yep. Clearly visible, and enforcing it.
You got it. You got it. I just wanted to.
All right, Raymond.
Thank you. Appreciate it.
Mariano. Yeah, you bet.
Before the pandemic, we usually have a high movies and everything, and a mining in their budgets, right? But after the pandemic, we started sending, they're trying to keep it easy. Electronically.
Yeah, that's cool. One exception, if an employee wants a printed copy, you have to give that printed copy. But that's only if they request it.
And also for us, for our superintendents and board members, we can send it electronically to their iPhones.
Sure.
Have it in hand.
Yep. It would be important for your employees to know
It is.
if OSHA said, how would you get? Yes.
Okay, all right. Yeah, another thing, well, I coming back in January for the OSHA record keeping. Because we have a two things, one thing with a guy who has a sweater in the clinic and for his eye injury, but it was a renal detachment. So we need to do the 7 days to do the.
Well, was it work related or no?
No,
Oh,
the doctor
then-
says, no.
No, that doesn't go on the line.